Monday morning. If you have any questions during the webinar, can you please type the question into the computer, and in webinar terminology, raise your hand and I will answer the questions at the or during the webinar and at the end of the webinar. So today we're looking at an overview of ESS BIZTOOLS with particular concentration on the Personal Property Securities Register system. We'll come to the PPSR in a couple of minutes. The first thing I just want to give you a briefing on is how ESS BIZTOOLS operates. We have papers that have been developed or articles that have been developed to assist accountants to deliver professional advice, to reinforce what you may have said to a client, to give them something to better educate them on the type of services that accountants can offer. Those papers, and there's 505 of them, have then been utilised to assist in the development of a range of products. We have business advisory services where we have 12 modules to assist an accountancy business to get ready to deliver business advisory services. I think that's very important as it sets the foundations right for what I believe for most accountancy businesses will become a very important component of your fee basis over the next few years. If not, some firms are going to have great difficulties. The other side of business advisory services, there are product modules. Currently there are 15. We're adding 3 or 4 new product models a year. Business Plus newsletter is a newsletter we produce every month except January to enable accountancy businesses to communicate with their clients. So the articles are targeted at small, medium enterprise operators. Client mentoring and coaching, there are 12 modules that are prepared to assist in educating your clients on the type of services that your accountancy businesses are able to provide. Leadership modules are 8 separate modules that have been prepared by an independent firm, Leadership Academy, that assist accountants to conduct leadership training in your own businesses, but also you could then offer the service to your clients. Client seminars stroke webinars are 34 pre-prepared seminars and webinars that you can use to promote services to your clients. Our suggestion is firms should be looking at running 1 seminar webinar a month, so over say 10 months. So that would give you 10 seminars to better educate your clients on the type of services that accountants are able to provide. ESS Biz Grants is part of the ESS BIZTOOLS Gold Package. It's a separate website. You can subscribe to it separately, but it's an ideal tool to assist in identifying grants, government grants, both state and federal, that an individual small, medium enterprise might be eligible for. The system produces a grant report together with a synopsis on the grants that are proposed for the client. You can produce an article on those chosen grants so you can have a conversation with your client. So the feature product we're going to look at today is the Personal Property Securities Register due diligence system. So why worry? I've had accountants ring me and ask me that. Why are you talking about this? Well, the reason we're talking about it is millions of dollars have already been lost by Australian businesses through ignorance of the operations of the Personal Property Securities Act and the Personal Property Securities Register. We believe that's something worth worrying about. Some accountants are saying to me, it's a legal issue. With respect, I think it's partly a legal issue and it's partly someone else. And if accountants are the trusted advisor to small, medium enterprises, I believe that something else role is with the accountants. I've worked with probably over 300 solicitors in my life. I can't really recall more than one or two who I think would have been prepared to go out and sit down in various clients' premises and instigate systems to ensure that the client is aware of their potential pitfalls from the Personal Property Securities Act. I really do believe that it's accountants' role to do that. And because of the way this legislation's been set up, and for the life of me, I don't know why we've got this legislation. I'm sure no business person, especially in small, medium enterprise, could have asked the government to introduce it. It was introduced 2.5 years ago by the then Labor government with no education campaign for business, and the Liberal government has also seen fit not to instigate an education program for business. Subsequently, I believe there's time bombs ticking away all over Australia. I'm told by accountants in New Zealand who have participated in some of our webinars that the same problem exists in New Zealand, even though they introduced this legislation in 2002. 12 years later, they've still got problems. Significant number of their business community do not know anything about it. And I really believe that's the problem we've got in Australia. And it's not only the business community. A number of accountants have said to me they don't really understand it. I've had people say to me, but Peter, it's called personal property. Well, personal property under this legislation means business property. So what's the problem? Businesses are losing assets through ignorance of the law. I find it very difficult to believe that someone who's paid for an asset or who has incurred a debt of nearly $1 million, as has happened in one court case in Western Australia, could lose an asset because they hadn't registered on some government register without the government formally informing them that they should do that. The other problem, I think, is the legislation's made it voluntary to do these things. So many people honestly believe if something's deemed to be voluntary, well, it mustn't be very important. Well, it is very important. Could wreck the business. It's also interesting to analyse court cases, and we are preparing some articles at present on the court cases that have already been decided. And we will be incorporating those new articles within the Personal Property Securities Register due diligence system. So if you do agree to subscribe today, you will be able to access those articles as we incorporate them in the website later this month and on an ongoing basis, because we intend to write an article on every court case that concerns the PPSA or PPSR. So already there's been action and assets lost, motor vehicles and trailers. One particular case, $1.4 million lost. Cleaning equipment and products. Someone used an old Ramalpa clause and also believed that by including a Ramalpa type clause on their tax invoices, they were complying with the legislation. Unfortunately, they were not. They may have somehow or other complied with the previous interpretation of the Ramalpa clauses, but they lost out heavily when they went to court with that type of defence. Inventory. There's been a number of cases where inventory's been supplied on a consignment basis. The business owner, the customer, has got into financial difficulties. A liquidator has been appointed, and millions of dollars have been lost to the businesses that in good faith supplied those goods on a consignment basis, but either overlooked or forgot or didn't think it was worth it. They didn't spend $8 for a 7-year insurance premium, in effect, to protect that asset. Assets hired, leased or stored on someone else's property. Somewhere between 40 and 50% of the court cases fit within that general description. You need to make sure that your clients understand the consequences of not properly formulating leases and hiring of equipment, and then if it's important enough that the business could suffer financial embarrassment if they lost that asset, they need to register that transaction on the PPSR. Machines owned by one company, and these machines were tractors and bulldozers, and hired to another company within the same group. Happens all the time, doesn't it? You have a property owning entity in a group, and you have a trading entity. Unfortunately, what was forgotten was that the trading entity had borrowed money from a bank. Somehow or other, they got into financial difficulties. A liquidator was appointed, and he was able to seize the assets comprising tractors and bulldozers that were claimed to be worth $2.2 million, and was able to sell them for the benefit of the secured creditor. A cabinet maker in Victoria was caught by the preferential payment rules. Apparently they'd made 20 upmarket kitchen suites and leased them to a developer who had developed a exhibition of houses. A rental payment was being paid. There was to be a lump sum payout at the end of 18 months. The developer got into financial difficulties. A liquidator was appointed, and he was able to successfully argue that there had been a preferential payment. There's been considerable costs incurred in the hiring and renting industries. I've heard reports of meetings of hiring associations where people have stood up and testified that they have lost $25,000 to $65,000, $70,000. None of those cases went to court, because obviously when the owner of the equipment got some legal advice, they soon realised that they should have registered, and because they hadn't registered, they had a problem. And obviously there's significant problems with preferential payments that I've already referred to. So why do I think it's an accountant's advisor's role to be playing a very important part of all this? Most accountants are very proactive about risk management. You ask clients whether they've got insurance policies. Surely this is now an insurance policy, to make sure that your client has thought it through. But in the first instance, it's very important to encourage your clients to get legal advice. And my suggestion is, if your client refuses to get legal advice, you should be sending them a letter and getting them to sign a copy of it and return it to you, and you file it, whereby you confirm that you've recommended that they get legal advice for the drafting of the terms of trade agreement and retention of title agreements, and indicating that they've exercised their right not to do so, and that you've advised them there could be significant consequences to their business. Because people will forget that you gave them that advice in 2, 3, 4 years' time, when there might be, hopefully there won't be, but there might be an insolvency event from one of their customers or an entity that they have placed some of their assets with. And people will be running around then trying to work out who they can take action against. So within ESS BIZTOOLS, we have developed a due diligence review system to assist accountants, auditors, trustees of superannuation funds to conduct a review to ensure that there's a clear understanding of what is happening within a business, so that a proper due diligence system can be implemented. Daryl Vardy, a director of SV Partners, participated in a webinar we conducted with Smith Inc. on the Personal Property Securities Register about 6 or 7 weeks ago. And Daryl made a comment in the webinar, and I subsequently asked him if he'd put that in writing. So Daryl's comment is, as an insolvency practitioner, quite often we are faced with suppliers who have retention of title, remalpa in place, but are not aware of the changes in the security regime effective in January 2012. Over 30 months ago. They're not aware of it. This lack of awareness amazes me, and it's predominant amongst small businesses. Unfortunately, the business owner generally finds out the hard way when faced with an insolvency practitioner who tells them that they no longer have the title and or ownership of goods. It's probably difficult enough for insolvency practitioners to make that comment, but it would be extremely difficult for an accountant for a client to be having that conversation with a client that just lost a lot of money under this legislation. When is the time to act? I think it's now. I've had accountants recently saying to me, oh yeah, well, that's all right, we'll do that next year. Well, next year might be too late for some of your clients. Hopefully it's not. Hopefully you never have a problem out of this legislation. But some people are obviously having lots of problems. There's one case going through the courts at present involving $50 million worth of assets in Western Australia. $50 million. A public company that's in liquidation. The assets were supplied by a Canadian public company and they didn't register, even though Canada also has this legislation. A transaction entered in today could cause a problem at some future date because of an insolvency event. Pardon me, but you can't run around in 3 or 4 years' time and then try to register. It's too late. There are very strict time requirements on registering a transaction under this legislation. The maximum time period is 20 days. Inventory must be registered before the grantor obtains possession of the collateral. So this has to be pre-planned. The documentation has to be submitted to the potential customer. They have to sign it. And the appropriate documentation has to be assembled so that the registration on the PPSR can be processed. If it's not inventory, you're supplying some articles, number of computers into a business, for argument's sake. You've got 15 days to register. And other security interests, intellectual property agreements, loans, those type of activities which also fall under this legislation, you have 20 days after the date of the agreement to register them. So the system we're going to show you now, we have a special price on at present which covers a subscription for 12 months, is $299 including GST. You can go to www.essbiztools.com.au and on the home page there is a banner saying Personal Property Securities Register. Click that and it will take you through to the registration page. So what I'm going to do now is to just go back into our system and we will bring up the area that deals with business advisory services, because personal property security is one of those. So there it is there. On each of our articles and modules we have a preamble or executive summary. That's what I've just clicked through there. Just why I'm bringing this up, we've had a good question here. Does this include a webinar we can give our clients? We are developing a seminar webinar which will be finalised when we incorporate the results of the court cases into our material. So by the end of November you will have a webinar presentation that you can give to your clients. I've gone to the procedure control form. Each of our product modules has a procedure control form. All of the ESS BIZTOOLS material is produced with these double lines. Above that is space for our accountant subscriber to include their logo, your name, address, etc. So this is a form which you download into your hard drive to utilize for your client. It guides you through the process of working your way through. So there are a number of papers. We'll just click to one of them. This is the main paper or article on the Personal Property Securities Act. This is complicated legislation, so unfortunately it's a fairly long paper. Don't forget, if you have any other questions, can you please type them up and send them to me. So this is the paper we've produced on the Personal Property Securities Register. So it has a list of contents. And then you get into the paper itself. There are links to other sections and other papers. Pardon me. So it goes on and looks at the history of the legislation. It did absorb about 70 other acts of parliament from the state, territories and federal government. So it's a very detailed paper which is written so that if you wanted to give a client the paper, you could, so they understand the change that has taken place from remarkable causes and why there is a necessity for them to register under this legislation. So I'll move back to the procedure control form. There is material in the system to assist you to prepare a quotation for the work to be done to your client. There is a template for an engagement letter. Obviously, you can draft your own if you wish. There's an assignment control form you can use if you wish. There is some information that you might care to send to your client. So if you wanted to give them a summary of the frequently asked questions on the PPSR, that information has been prepared and is available for them to use. You could badge this document again with your logo and your name at the top of it. And there's a summary of some of the questions and the answers. That will enable you to better communicate to your client on this legislation. There's other articles there you could give your client on the implications for business and 10 myths. There are some links to some videos. The main work document is 1645, and this is a work checklist that encourages you to work through and look at the various assets. So we've gone through and dissected the assets into fairly detailed lists so as to assist in prompting you in undertaking a due diligence review not to forget anything. So instead of just calling it stock, we've dissected it then into consignment stock. Sometimes the client might forget to tell you they've got consignment stock, or demonstration stock that's situated somewhere around the countryside. And the key question then is, have they entered into any sort of trade agreement or retention of title agreement, and were they drafted after January 2012? Should then look at livestock. Where's it situated? Is it livestock on agistment? Big problem at present. Our office is in Queensland and there's massive droughts. There's droughts in New South Wales. So there'd be a lot of livestock being moved around on agistment at present. Unfortunately, there's also grazing properties being caught up in insolvency events. So it's a potential big problem for people moving livestock around. We've included thoroughbred horses because of an infamous case in New Zealand where the owners of a ex-racehorse that was at stud lost it in a case. The liquidator was able to seize it because they had not registered on the PPSA. The New Zealand media claims that that horse was worth over $2 million. Crops have got special treatment under this legislation. We've got a question in PPSR applying to non-business assets. If the asset is worth less than $5,000, it doesn't apply, and it has to be on a business relationship. So the question was a daughter having a horse that is on agistment. I'd be asking a solicitor about that one, just to make sure. If the horse is worth over $5,000, yes, I think it would have to be registered if you want to protect it. I've had another question, the process actually, how do you actually register with a PPSR? I'll comment on that a little bit later as we come to that process. So we're looking at goods, all types of goods. One of the items that's occurred in this legislation is, in my opinion, an improvement on what happened previously under the RMAPA clauses, is that goods attached to other goods can receive some protection now, as long as the client has gone through the proper preliminaries of having a terms of trade agreement and a retention of title agreement. And that particularly applies where something has been sold to someone, say a set of stairs has been welded to other equipment within a coal mine. Previously, a RMAPA clause possibly could not be utilised. It would not be easy to go in and repossess the stairs on that basis if they're welded to something else. But under the PPSR legislation, that asset is able to be protected. And also mixed goods, especially grain farmers, sugar farmers, where their product is being mixed with other suppliers' products in the one facility, can get protection. And in fact, you can trace through from ingredients through to a final product, through to potentially recovering from the debtors to the customer's business under this legislation. There's also special protection for suppliers of fertilisers, seeds and pest control, and products that have been supplied as feed for livestock. So there's some protections for those items, but I repeat, the preliminary registration of forms, the signing of forms so that they are the basis for the registrations, have to be done. Artist works come into this very heavily. There's been a couple of major issues in New Zealand of paintings, sculptors, designs, carvings. If they're being produced as a business and stored on someone else's premises, there can be real issues. Plant equipment made available to customers. The big question is, where are they situated? On leased premises or someone else's premises? And we've listed some of the items that you might consider there when you're looking at it. Scaffolding, tradesmen's tools, cranes, plant and equipment. All needs to be thought about and analysed as to what is happening in the customer's business. We then get to a situation where there's formal leases or hiring agreements. Items which are on your own premises, as I previously indicated, are not really a problem. When you get into leases, lease for an indefinite period can be a real problem. Leases up for up to 1 year are basically not a problem, but these last two categories of leases up to 1 year automatically renewable and terms of more than 1 year, your client's in real strife if there's an insolvency event and they've got those types of arrangements and they have not registered them. Motor vehicles, first of all, just looking at where they're situated, where they're just stored on someone's property. Same sort of issues arise. Then we get to the situation where there's a hire or a lease of vehicles. At this stage in the legislation, there is a 90-day period for any motor vehicle, plane, boat, etc. that has a serial number. Now, the House of Representatives has passed an amendment to extend that to 1 year, but it has not yet been passed by the Senate. And the way this Senate's operating, I wouldn't be holding my breath as to when they're likely to pass it. That will then bring Australia into line with New Zealand, and seeing we based our legislation on New Zealand, one would wonder why anyone ever decided to introduce a 90-day period, because it's been one of the contributing factors to a significant amount of the losses that have taken place. But at this stage, the legislation has not been changed because it hasn't got through the Senate. The legislation can apply to boats and other types of watercraft. So we'll just move on through a few of these now then. Aircraft come into it. So the purpose of this form, of course, is to start asking some of these questions to make sure a client hasn't gone out and bought a boat or bought an aircraft or leased one, and what are they doing with it. Debtors can be a big issue. Having a remalpa type clause on its own does not give any protection to anyone to be able to go and seize an asset or anything like that. They have to have had a terms of trade agreement and a retention of title agreement signed with the registration made on the PPSR to be able to get any protection. Licenses and trademarks, things that a lot of people probably don't think about, can be caught under this legislation, especially when they've been hired or rented or assigned on some basis to some other organisation. Might even be to one of your own client's subsidiary companies. But if that company has borrowed money, there's always the risk that a liquidator or receiver could get appointed. Same thing applies to intellectual property. Has it been hired to a marketing type company within the group or an external marketing company to market it? Could end up causing embarrassment. Loans made from the holding company to a subsidiary company. The holding company thinks they can claim their money back at any time, but the subsidiary company's borrowed money and a liquidator is appointed. Statutory fishing rights, it's in the legislation, that's what I included in the form. I haven't found anyone that's told me what it's all about yet, but obviously there are statutory fishing rights around Australia, and if they exist and you have a client that's got them, it would appear to me that you should be making sure they're registered under this legislation. Assets held in trust. Service company entities, that example of a court case where plant and equipment owned by a asset owning company rented to a trading type entity had a lot of the hallmarks of a service company entity. A lot of accountants, of course, have got assets owned by one entity hired to another. You need to be very careful as to who then is borrowing money if you haven't registered the transaction. One of the big questions in all this is, would your client be financially embarrassed if they lost the asset or never got paid for that by that debtor? Now, I made a comment at the AEST conference in Melbourne 2 weeks ago to a couple of accountants that I was talking to, and I said, well, that could range from $5,000 to $50,000 to $100,000, depending on the client. And one of the accountants had a different opinion to that. He said, oh no, I think my clients would be whinging if they lost $500. So I then asked him if he'd ensured that his clients were registering basically every debtor and wherever they were placing assets. He said, no, but now that I've talked to you, I'm going to go back and make sure they are. This is a fairly cheap insurance cover, $8 for a 7-year cover. So I'm just going through the rest of this form now, which is talking about terms of trade agreement. I'm just looking for a couple of other things we want to look at. We've got information in here really emphasising you need to have these documents dated after January 2012. But one of the big issues I think as the professional advisor you need to be considering is the degree of potential exposure or total exposure that a client is prepared to accept. So we've devised a form to assist. In my opinion, if a debt is going to go bad on one of your clients, they're not going to be in the 30-day column. They're probably going to be in the 60, 90 or 120-day column. And therefore, at the very start of a transaction with a client, we're recommending that your client establishes what they think the monthly sales are likely to be. And if they're going to be, say, $10,000, and if you took that worst case scenario, at the end of 90 days, they could owe $30,000 or into 120 days, $40,000. And that's the amount that should be taken into account in then looking at what's the client's exposure limit. What are they prepared to lose if someone doesn't pay them? So someone looking and saying, oh, it's only likely to be $10,000 might have a completely different attitude if they realise, in fact, by the time this problem really hits home, it could be a $30,000 to $40,000 problem. So perhaps they should have registered that client. They don't have to register every invoice, but they have to decide fairly early in the piece what they're going to do. We have a checklist there of who some of the potential customers are. And I don't think people would be insuring federal governments or state governments. Some local governments around Australia at times get a bit shaky. I don't know. And maybe they've got to make sure they're not dealing with some obscure subsidiary or offshoot company of a local government that the local government organisation may or may not stand behind. But then you get into large public companies. Well, when you look at the amount of cases that are starting to come through, it's very obvious there's a lot of businesses having insolvency type events occurring against them. And some of the companies that have got into difficulties were quite large. So perhaps it would be a good idea to look at covering all transactions. But most definitely when you start getting back into small public companies and other proprietary companies and other businesses. So that's a question to look at, and bearing in mind that these documents have to be lodged in a certain way to obtain the proper securities, which we really haven't got time to go into now. The total exposure is also then looking at your trade financing statement. So this form's purpose is to say, okay, we've established that the amount of indebtedness that we're going to have with this customer is of an amount that would financially embarrass the client if they weren't paid. And therefore we need to make sure we've got a terms of trade agreement. So the first thing to do then is to make sure those agreements are being promptly sent to the customer, to the end customer, the person that is called the grantor under this legislation, because they're granting your client the right to register this transaction on the register. Those documents have to be signed and returned to your client before a registration can be made on the PPSR. It's then necessary to finalise a financing statement. So a financing statement has to be prepared for every entry on the PPSR. So this form allows you to record that you've done that. And we've included on the second page of that form just a little summary to say if it was inventory, what date did you lodge the document on was the financing statement lodged on the PPSR, and what date did the customer obtain possession of the goods, because the registration should have been made before the goods were delivered. I'm just getting a message. I hope you can all hear me okay. There's just a message coming up on the screen here from the webinar people. You will then receive a verification statement from the PPSR, and then the general legal position is your client has to supply a copy of that verification statement to the grantor, in other words, their customer, unless the customer has specifically opted out of receiving the verification statement, which will be part of the terms of trade agreement. So your client has to send that verification statement. That's why we're recording it there and recording the date that it's been sent. And then another very important thing turns up. It's called a verification token. And that has to be appropriately filed, not given to the grantor, the end customer, because it's the token that's needed to authorize the withdrawal of the registration at some date in the future. So it's not very smart to have that in the grantor's possession. It has to be in your client's possession. They should file it so they know where it is, and it should be safeguarded so that it can't be misappropriately treated. So that's the sort of run through that's occurring on those documents. So the strategy is to see whether the customer could be financially embarrassed, and then to ensure that everything happens within a time frame. And the time frame's short. Before supply for ingredients, within 15 days for most things, and 20 days if it's a intellectual property loan type agreement. I've now brought onto the screen the other document we have, which is looking at where assets are situated. And it's trying to assist in identifying if what's out there on an indefinite period, or what's going to be on an indefinite period, and therefore should the document be lodged. So this really requires someone within your client's business to be monitoring either daily or at the most weekly what is going on with the assets of the business. Where have they been left? Have people entered into arrangements to rent something on an indefinite period basis and haven't told anyone in control? Is that asset value an amount of money which would financially embarrass the business if they lost it? If they decide that they're prepared to wear things that cost under $5,000, well, okay, that's their decision. But I'm suggesting that it would be a good idea to have a procedure in place to make sure that proper consideration was being given to this. So that's what that form there is about. It's working through and saying, where are our assets? On what basis are they being left in certain situations? Should we be registering to protect our interest? And then we have a form which will help you to list those various assets. What are they? What are they worth? And our suggestion, and obviously what this form's also about, is list them out now so you know what your value of the assets are, so that staff can be made aware that certain assets have either got to be on long-term leases and appropriately registered, or there's got to be some decision made as to what's going to happen to them, so that it's not a mad rush on a Friday afternoon trying to work out what the policy is going to be. And every business will have to set its own. I hope that assists in giving you an overview of what we have built into the system in that area. I just want to keep on going now to have a look at one of the questions was about lodging on the register. You have to prepare the financing statement. You can't do that until the terms of trade agreement is signed and returned, and you're then able to proceed with that. One of the questions we believe you should be looking at is if the business is sending terms of trade agreements to customers and they're not signing and returning them, why not? Someone needs to be following that up. They should be getting them back, because the decision should be your clients to make whether they're going to register this particular customer or transaction on the register, not for the customer to make. You can also obtain a far superior registration called a PMSI, a Purchase Money Security Interest, and there's some summary there on that. It can apply to inventory, non-inventory and other security, but the documentation definitely has to be lodged by those time deadlines. So looking at the registration overview, that item 26 on the page you have there now, has the business implemented the procedure to ensure that when new customers complete a credit application form, that a terms of trade and conditions of trade agreement is prepared and forwarded to the new customer for signature and returned before any product is supplied, unless you've decided not to register that particular business on the PPSR. Is the business a system to correctly identify the type of collateral being secured? You have to correctly identify the collateral. And we've got some examples of that there. Is the business appropriately describing the collateral in the registration? It's a good idea to describe it as all goods now and in future supplied by the secured party to the grantor, including but not limited to. If you don't have that type of clause, to have effective protection, you'll have to be protecting every individual invoices. The parties have got to be correctly named. The ACN has to be correct, otherwise the registration is null and void. So there's a few things there which we'll list through the procedures that have to be adopted. We've concentrated in this documentation in giving accountants a procedure to undertake the due diligence review to make sure the client's aware of their position, and hopefully giving them a pathway to decide how they might register. We also have some specific forms that are being prepared for individual businesses. There's 17 of them at present. We've got a few more to be added to that you might like to use with specific customers. So the one I have on the screen is looking at retail businesses. That you might want to look at. I've just got a few more questions here. I'm just having a look at them. So Someone's asked me a question and you've stolen what I was going to say next, but that's good. Thanks, Greg. I assume we should be having a conversation with business clients at least annually then. Most definitely, yes. I think this is an ongoing review, and for some of your clients, it's probably should be held every 6 months, because things will change, staff will leave, people will forget the importance of this whole process, and it's not something that's going to be staring people in the face. And hopefully your client will go their whole career and not have any problem under this legislation. They might whinge then that you put them to all this extra work, but it's an insurance policy. Everyone will sleep a lot better if there's appropriate registration and in the unfortunate event that there's been a problem. So yes, I think you should be undertaking a review every 12 months. The people the firms that are already using our system are conducting reviews time periods 1 hour to 3 hours, although in one case, chaps told me he spent 8 hours. There was a few complications there. It was probably a full debtor system review and a few other things thrown in. So it is part of the a further cost to business to be undertaking work. So that's the overview there. I'm just maneuver back here to the system where we were, back on the personal properties securities legislation. There are a few more questions, so please just bear with me a moment and I'll just have a look at them. The question is, what if assets are located overseas? I'm not ducking the question, but I think it's probably something you need to ask a commercial solicitor. But in my reading of the legislation, I don't think you have to worry about assets situated offshore. This is Australia. What you would have to be very careful of is that other country has not got the same legislation. Now, I understand I had reason to check Papua New Guinea a few months ago because I was advising an organisation that was placing assets into PNG, and as of probably around May, the Papua New Guinea Parliament had passed a piece of legislation called the PPSA, and it was waiting for their Governor-General's assent. Now, I haven't followed through whether that has yet occurred. Obviously, New Zealand's got a PPSR legislation. Canada's got the legislation, and I gather from some of the court cases where the Australian courts have referred to decisions made in Canada, the individual provinces in Canada have got their own legislation. So that would be a real jumble, I think, if individual provinces are making their own amendments to it. And I'm told America, or some states of America, have got some type of PPSA type legislation. So you need to be careful what overseas country that you were dealing with, because the $50 million case that I referred to before, the supplier of the transformers, there's 4 of them, obviously worth $12.5 million each, was a Canadian company. So they've supplied into Australia. You'd have to assume we're ignorant that Australia had this legislation and have been caught. If registration is not done within the applicable time frame, what options are available? A good question. Apparently you can apply to the court, but any of you who have ever been involved in an application to the court will know that it is a time-consuming and quite expensive process, and you would want to have a very good reason to argue. So the legislation does leave the loophole that you can apply to the court, but it could be quite costly, and it would have been far better to have paid the $8 in the first instance to protect your client for those transactions. So that's our webinar for today. Just a reminder, sorry about that, I pressed the wrong button. Just go back one. The special offer we have for subscribing to the Personal Property Securities Register due diligence system as a standalone product, but receiving all updates that we place onto it over the next 12 months. You'll have 24/7 access. Is $299 including GST. Just go to our ESS BIZTOOLS website. You'll land on the home page, click on Personal Property Securities Register, and the system will take you through. However, if you decide you would like to be a subscriber to the total ESS BIZTOOLS Gold package, you receive access to the Personal Property Securities Register due diligence system as part of that subscription. That subscription costs $2,970. The PPSR package includes a lot of other things: ESS Biz Grants, our newsletters, and our business advisory services modules. If you have any other questions that you think of this afternoon or tomorrow, please send me an email, peter@essbiztools.com.au, and I will reply to you. If you want any assistance from a legal practitioner who is very much aware of this legislation, has given us a lot of assistance and advice, I'm happy to give you his details if you want to send me an email asking me that. He's based in Melbourne, but he is undertaking work on the PPSR throughout Australia. So thank you very much for participating in this webinar today. You will be receiving a questionnaire a survey form after the webinar. It will take about 1 minute to complete. We'd appreciate it if you would complete it and send it back to us. And either tomorrow afternoon or perhaps Monday, you'll be sent an email that you can then go to YouTube to view a recording of this webinar. Thank you very much. Have a wonderful day. Goodbye.